Thank you for joining us today for another edition of the Elville webinar series. Today is Friday, January 23rd. Our topic is a new presentation developed by Steve titled Estate Planning is About Love. And there's nobody better to guide us through this conversation than our managing principal and lead attorney, Stephen Elville. And how are you today, Steve?
Jeff, I'm great. I'm a little daunted by the possibility of the snow. Are you ready?
I haven't heard of any snow. What are you talking about?
Oh, okay. Well, it's all going away. That's good to hear.
It's going to be a doozy. I agree. So busy weekend for everybody. So including us, we have our client care program event tomorrow morning. So hopefully everything is smooth and everybody's safe out there. But a few housekeeping items before we begin. We're going to talk more than just about snow today. We always welcome your general questions throughout the presentation. So please submit them in the questions panel. We'll pause periodically to address them. And yesterday, you should have received the presentation slides by email that Steve is going to be referencing today. And these materials are also available in the section marked handouts on your screen to download it as well. And following the webinar, you will receive a brief post-presentation feedback email. And we really appreciate you taking just a couple minutes to share your thoughts about this brief but important survey. And one question to consider as we begin, have you achieved your planning goals, or have those goals shifted or changed since you last reviewed your planning? And here at the firm, we serve as a trusted resource for families navigating all aspects of planning, whether you're starting fresh or updating old documents, addressing an administration matter, exploring special needs planning, or something else. And Steve and his team are always here to listen, understand your unique situation, and help create a clear path forward. So I want to talk just for a couple minutes about the firm and Steve to give you some context of who you're with today, and then we'll jump right in. So we are Elville & Associates. You should be able to see my screen here, founded in 2010 in Columbia by Steve. We have many different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, business law and succession planning, estate and trust administration, guardianship and litigation, and different types of tax planning and asset protection techniques. We have 14 attorneys, 13 staff members, and 3 locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, it's always been the same in the 16 years we've been in business and the 13 years I've been here, and it is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at Elville & Associates, and we do it in many ways. Just a few of those are through the planning processes with our clients, and we have different programs to suit all families and individuals here at Elville & Associates. Also, as you can see, by way of our educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, which I alluded to earlier. We have our first quarter event coming up tomorrow morning. We're one of only 2 firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. And just a bit about Steve. Steve's work as an attorney for over 25 years has been centered in elder law, special needs planning, and estate planning, a member of many different membership organizations around the country, professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, Wealth Council, nationally recognized peer groups where he goes to learn and teach fellow attorneys. Steve works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. A very seasoned speaker presenting at many different types of venues and webinars each year. And Steve was also named to the Maryland Super Lawyers list for a 10th time and 9th consecutive year in 2025. Actually, that should be 11th time and 10th consecutive year for 2026. I need to update that. Congratulations, Steve. Steve also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charity that he founded in 2014. I am very fortunate to be a part of that. We just had our board meeting, our first quarter board meeting from 8 to 9:30 this morning, and it was powerful. And we have a lot of great ideas and of great vision for where we want to take the charity in the next year and into the next 10 years and beyond, and hope you'll be a part of it. So if you want to learn more about the Elville Center, please reach out to me. I may reach out to you, and we'll talk and share our story about how we work to make a musical difference in the lives of children each day. So with all that said, Steve, the floor is yours. I'm going to make you the presenter.
Thank you so much, Jeff, for that wonderful introduction.
It's my pleasure.
And all the wonderful things that you do for our firm's charity and for our firm. And please be
Yeah.
safe over the weekend. Jeff, I heard as we're making the transition here, I heard that you have a snowblower and you're going to be willing to go help blow up people's lanes or things like that.
I am the snowblower.
I got you. You are the snowblower.
I have two strapping kids at home that are almost 19 and 16 and a half, and old dad is the one that goes out and shovels the walkway and the driveway. So.
All right. Well, be careful out there.
You too.
Well, good morning. Yes, good morning, everyone. And thank you for spending time on your Friday morning with us. We know that you have many other things that you could be doing right now, but you're going to be spending some time with us this morning. We're going to be efficient. Happy New Year to you. And I know some of you were very kind to send comments about this presentation and how you were looking forward to it. So I hope you're able to take away something substantive when we talk about estate planning is about love. And I just want to say I'm very, very lucky to be with you to be able to present this material. I've been thinking about it for a long time and been convicted in my soul, so to speak, that at the heart of estate planning is the concept of love in many different respects. And so we're going to walk through that in a very non-technical kind of presentation. However, I want you to know that I just came back from the Heckerling Conference in Florida, which is the big annual estate planning conference that many estate planners go to. I have never been more excited about the possibilities, the flexibility, the possibilities of what you can do in estate planning. So just know, even though this morning we're going to be spending a lot of time on the non-technical side of things, the legal technical side is very robust, and the ability to plan with confidence more and more through certain techniques that provide for flexibility in the future has never been greater. So I'm very, very glad to be with you this morning. I want to encourage you to ask questions. I want to encourage you to share if you wish to share. Jeff has done literally hundreds or maybe even thousands at this point of these webinars. He's very skilled as a moderator. He will see your question. He will interrupt me if we need to stop. So think of this as an informal presentation as well, where you can sit with your tablet, your tablet of paper or your electronic tablet, your computer, your device, your coffee, tea, and just enjoy this workshop and hopefully take away something very substantive from it. All right, well, that said, we're just going to go through the material now. We'll get started. But I'm going to start by simply asking you to take just a moment, maybe 60 to 90 seconds. And I want you to think about why you're here today. Why are you taking time on a Friday morning? What is the real foundational reason for that? And I'm going to ask you the big question, which is, who do you love in your life and what do you love? Let's take 60 to 90 seconds just to think about that. There are various aspects of how to think about this concept in terms of planning. There are various ways that you can express this. There are tools, but we want to start with, what is it that we really care about? Who is it that we really care about? And of course, this is just a getting centered kind of exercise here for 60 seconds. Okay, now, as we start going through the slides, remember that this is a presentation that, and Jeff, I'm just going to start my slideshow, I guess, which I had not started. This presentation is not legal, technical, as far as attorney-client privileged advice. So this is not a substitute for that. Nothing is a substitute for legal counseling. We can meet in person or virtually to try to have an attorney-client relationship, but this presentation is just high-level educational material. All right, so we're going to launch now into the presentation. Estate planning really is about love. I've thought about this for years, as I've mentioned. I've seen, tens of thousands of situations. I have seen crisis situations. I've seen advanced planning situations, tax situations, elder care situations, special needs situations, and on and on and on. But I believe at the heart of it is this concept of love, caring for those people or those things in your life that matter the most. So this is about providing clarity, easing burdens, reducing conflict or conflicts, and protecting values and legacies, you know, the things that you care about most. Now, let's talk about why I would argue estate planning is an act of love. Well, there again are very, very broad reasons or arguments for this. Love of your spouse or partner, let's just start there. So ensuring the financial stability for your partner who may survive you or your spouse. Avoiding court involvement, okay? And we don't want this clarity to be absent, but especially if the clarity is not there, we want to avoid court involvement. Obviously, that would not be conducive to a smooth administration. We want to provide explicit guidance, and I think many people are not aware that you can do this. So explicit guidance for healthcare decision-making, for example, could come in the form of a very broad advanced medical directive that goes into more detail than just the basic statutory provisions. So just remember, through memorandums or through lifetime discussions about what your healthcare wishes are, you can express yourself through the advanced medical directive itself or a memorandum. And it's about preserving your dignity if there is illness or incapacity with regard to spousal or partnership relationships. Now, it could be love for your children. And of course, many people are driven to estate planning by the love of a child or for children. Making sure those children are protected. Now, the term protection, okay, that has many aspects. At the Heckerling Conference, I heard two webinars or seminars, I should say, about divorce, the possibility of divorce. So one aspect of protection is protecting a child from bad things in life like divorce, car accidents, bankruptcy. Divorce statistics coming straight from the Heckerling Conference, 43% of all first marriages end in divorce. Approximately 66% of second marriages end in divorce, and 73%, almost 3 out of 4, third marriages end in divorce. So love for your child can drive us to plan to protect them financially and otherwise from a divorce. Providing clear instructions to prevent confusion. Obviously, this is one of the big drivers of the love that you have for your children. Supporting them during grief and not leaving them to guess about your wishes. So love could extend to the idea that my clarity, my instructional advice to them, or my guidance is actually supporting them during their grief when I am no longer here. And of course, avoiding conflicts between siblings. Now, tomorrow at our client care program at Anne Arundel Community College, we're going to be talking about a segment of our presentation about what happens when we have to think in terms of leaving unequal shares between children. You know, the presumption for most of us our entire lives is that we are going to leave equal shares. Now, one of the big confusions or troubles that we have in planning is accepting the fact that we may have to think in terms, although we normally wouldn't unless we had to, think in terms of unequal shares between how we're leaving our assets to our children, whether it's because one child is disadvantaged and disabled or for other personal reasons. So giving yourself permission to think along the lines, giving yourself permission to sit and design how that should look if there's going to be unequal shares, and if there's going to be unequal shares, trying to design it in such a way to minimize conflict, even though it's very difficult to think about. All these things are loving yourself, which we're going to talk about, giving yourself permission in the estate planning process to think of it as not just a set of documents, but as this broader act of love, which hopefully would make it easier for you to think in terms of planning, which is not easy. And I think many estate planners like myself have been doing this for so long that, you know, we sometimes may forget how difficult it is to come in and share personal information, personal thoughts and ideas, and actually plan for our demise. It's a very difficult thing to do. So this particular thing, avoiding conflict between siblings at your, or meaning your children at your death, it can be a very painful thing to think about, but something that you need to give yourself permission to be able to think about. Love for your extended family and future generations. So there are tools available. Passing along values, okay? Passing along values could extend to how you structure a trust, not just for the legal technical purposes, but for purposes of passing along your values. At the Heckerling conference, we were talking about, just as a digression for just a moment, we were talking about non-charitable purpose trusts. There are ways, and I know some of you have ideas about leaving assets in a further trust for something that you love, whether it's future generations being able to get education, whether it's an organization that is not necessarily a purely charitable purpose or a mixed purpose. Well, there's one state in the country that sanctions the use of non-charitable purpose trusts, and that's Oregon. So in the future, not so long from now, I'm going to be writing an article, is my intention, on the use of non-charitable purpose trusts. But passing along values could be in the form of a trust like that. It could be a memorandum of intent that you create that passes along your values, your goals, your thoughts and feelings about your legacy. Ensuring the long-term care stewardship of family assets. So we are in an environment today of increasing wealth, laws that perpetuate wealth. And again, whether the wealth is moderate or whether it's a very high level of wealth, you can express how that stewardship of those family assets can be characterized over a long period of time. We're also living in a world of multi-jurisdictional practice. So there has never been anything like this before, where you, when you are planning for the long-term stewardship of your family assets, you can actually plan for those assets to be administered for a long period of time in various jurisdictions. And some jurisdictions are extremely favorable to honoring wishes of family members, such as South Dakota and other jurisdictions. And this is the world we're living in, where you not only can extend this kind of planning in your thoughts and ideas and in the planning itself and through memorandums of intent or letters of wishes, but you can also choose the jurisdiction for which or in which these assets will be administered in the long term. And of course, with a goal that might be an act of love is creating continuity and harmony across generations through the use of special fiduciaries. So all of these things are why estate planning may be considered an act of love. But then I mentioned loving yourself, and loving yourself might be about maintaining control, not only at death, but during your lifetime, ensuring that your wishes are respected by using these tools. Think about this for just a moment as we step back. How many millions of trusts must there be out there, for example, for someone who might plan to leave assets in a further trust? Well, millions of trusts, obviously. But how many of those trusts actually are drafted or articulated in such a way that your wishes are really well expressed? How many of those trusts have memorandums of intents? Or how many of them have letters of wishes attached, okay? How many of those trusts have flexibility built into them? Well, not very many. And so the good news is that now we're living in an environment where even if such flexibility wasn't built in, there is a certain amount of flexibility, which is an educational tool in and of itself that you may wish to avail yourself of. But what we want to do is make sure in thoughtful planning, in loving type planning. We want to make sure that your wishes are respected and that you've gotten your ideas out on the table. Loving yourself is also about giving yourself peace of mind, knowing that your planning does reflect these values and that you've actually been given an opportunity to express them. So let's talk about why estate planning is an act of love as we continue. It's emotional. You know, today, I know some of you might feel emotional about this presentation. You might be sitting in a place in your life with a certain health issue or health worries about others or non-financial worries about family members. Or perhaps you have a family situation where it's not going to be conducive to leave equal shares among children or grandchildren or nieces or nephews. Basically, what we are saying when we take a more non-technical approach, which is one side of estate planning, it's not the only side, but at least having this giving ourselves permission to be emotional about estate planning. I want life to be easier for you. This is what we are saying to people, that we leave assets to you. I want to protect you, for example. I want my values to endure. Now, I've been doing a lot of talking about trust. Some of you may value simplicity, leaving assets outright, okay? Perhaps you feel that that is an act of love because you are simplifying everything for your beneficiaries. We have to respect that that possibly is how you feel about it. So estate planning is legal technical and it's also non-technical. You have to feel emotionally in your heart. You have to feel that you are having the kind of plan that represents your values, and your values could be values that don't have anything to do with long-term protection, but we want to be educated about that, about the advantages and disadvantages of those protective type plans. But we want to also give credence that your values may be simplicity. Keep things simple, don't overcomplicate things, and maybe your act of love is making things extremely simple for your beneficiaries. Again, there are pros and cons, and there are many advantages, in theory, to leaving assets in further trust. Those have to do with creditor and divorce protection, for example. It also has to do with excluding the growth of assets from federal estate tax in the future, no matter how big those assets may grow, and so forth. But that kind of planning does not necessarily mean everyone has to be interested in that. So whatever your goals and values are, that is your act of love that you are projecting out into the world. So on the human side of estate planning, which is what we just talked about, planning and being very thoughtful, this clarity reduces stress, not only for you, but it will reduce stress by extension to family members, depending on what that goal was. Planning generally prevents conflict. It does not necessarily prevent conflict 100%, but being thoughtful about it is getting ahead of it, okay? Proactive planning avoids crises, and I think that is a very important thing to bring out, whether that's elder care planning, whether that is leaving assets in such a way that it is a mess to clean up, and that's a crisis. Leaving assets in such a way that there's not liquidity, leaving assets in such a way that a lot of stress comes down on your loved ones. Obviously, we want to avoid those kinds of crises. And of course, estate planning promotes family harmony, especially when we are doing it during life. Not all of us are blessed with families that are in harmony, but this is obviously an aspirational goal. We want to create harmony during life, harmony after our passing. Let's talk about how clarity reduces stress. Well, when your loved ones or trusted advisors and fiduciaries know what to do, emotional strain generally is going to be reduced, okay? And many of you on this webinar have lost loved ones or friends or relatives, and you've been in a fiduciary position where you are in a position to have been under this kind of stress. So clearly, there's no amount of clarity that really is too much. in my opinion. And I've been very blessed to deal with some clients that leave absolutely nothing to chance. They are very methodical about their planning, and I have to take my hat off to those clients because in the end, given all the variables, all the randomness that occurs in our lives, from financial to health to other influences in our lives, this clarity, this laser focused clarity, this is an act of love in and of itself to reduce stress for others. It removes guesswork during your life at difficult moments. Many people think of estate planning as only what happens at death. Obviously, that's not true. We are having lots and lots of people live longer lives, and so we have incapacity planning issues. We want to make sure that we understand that financial powers of attorney are arguably the most important document in estate planning, financial powers of attorney. And those powers of attorney can be drafted in very plain vanilla ways, or they can be drafted in very broad ways, depending on your situation. So we want to remove the guesswork during our lives. And we want to remove guesswork if you're married or you have a partner. We want to remove guesswork, obviously, on the first death. We want to give families the ability to express relief because their instructions are clear, okay? And so this is, not only relief for you to have expressed this, but family members we are seeing, they actually are so thankful that you were so thoughtful during your life that you made things very clear and accessible. So there's no price tag that you can put on this in terms of how valuable this is. Now, this prevents conflict, obviously. Many of you have had situations where you've actually experienced family conflict. I am amazed sometimes at how many clients I have seen and dealt with that have been involved with the deaths of parents or other relatives with disputes. And many of these disputes arise from uncertainty and assumptions. Now, let's be fair. Many people attempt to do estate planning and they do it, maybe do it once and do it well, but then life continues and the estate plan is never updated, or the estate plan wasn't comprehensive enough from the beginning and it was never revisited. So sometimes family disputes arise from uncertainty because there was no planning. Sometimes the disputes arise because there was planning, but that planning was not updated over time, or that planning was not comprehensive enough. So be thoughtful about and be honest about what your family situation is, because when you are that way and you convey that information, the attorney should be able to take that information, feed it back to you in the form of best practices about how to deal with these situations and try to prevent conflict in advance. Clear instructions equal fewer disagreements. Obviously, that's what we're saying. And a plan that's grounded in love supports unity and long-term harmony. Again, this is doable for a lot of people. Sometimes this is not doable due to family situations, and this is where the pain, this is where the stress comes in. But I believe that through the use of certain tools and through a conviction that you are acting from a place of love, you are acting from a place of professional advice, you are acting from a place of the highest and best practices. I believe this is something that can ultimately end in a planning approach that you can live with and that you can have personal confidence in and reduce stress. Now, obviously, crisis planning is not what we want to see. We see too many crises in the world, decisions that are made under pressure. Well, there was no loving planning here, right? There was no thoughtfulness. And of course, life is full of random events. So even when we have the best intentions in the world, planning can turn out to be something that caused, or no planning, because there was not enough time to plan, or there were no backup provisions available. Planning can cause, of course, lack of planning can cause pressure and really, really poor outcomes. These outcomes could be loss of protection, loss of assets themselves, tremendous tax liability where tax liability could have been avoided. All of these things come from a lack of a loving, thoughtful approach to planning. Now, courts become involved, and this is also another aspect of it where tremendous amounts of money can be lost due to court involvement. Perhaps it was something benign, basically, like you wanted to avoid the probate process. And the probate process would have been much more expensive, theoretically, than a non-probate disposition. So in that sense, a court became involved. Or because your instructions were not absolutely clear, or your planning wasn't bolstered enough through counseling and good drafting, a court became involved in a dispute. So this is probably arguably not the kind of loving planning we want to do. So if I were to stop the presentation right now, what would I say? Well, I would say, everything could be summarized by this third bullet point here. That love in planning shows itself by being intentional, okay? And, if we had to boil this presentation down to how do we plan lovingly? How do we avoid crises? How do we provide for smooth administration? How do we try to reduce conflicts? It's about being intentional and understanding that planning is not just a one-time thing. I was meeting with a couple the other day, and I was congratulating them. They had done their planning in the early 2000s, and I looked back in my records, and they've been very consistent every few years to check on their planning and to update their planning. So that's what being intentional is. Jeff and I have done a webinar, and I'm sure Jeff would be happy to send it to you, about how to be intentional and how to try to achieve perfection in your estate planning. And this outlines, that presentation outlines how to be intentional, how to make this climb, this little bit of an uphill climb throughout life, to make sure that the planning works the way you want it to work. But not only that, to look at it in the lens, through the lens of love, and say, am I accomplishing my goals and values and the things that I'm trying to accomplish in a loving way, if for no other reason than to give myself relief that I have done the best planning I can do, despite whatever circumstances you are facing. Now let's talk about legal tools very briefly. Many of you have seen our webinars, and I thank you if you've come back to watch this one. A basic will plan, the structure looks something like this. The will takes care of what happens at death. Powers of attorney and advance directives are the lifetime tools. In a will-based plan, a power of attorney controls all the financial assets. And of course, some people consider the advance directive the most important of all the documents. But you can articulate exactly what you want in a will, and you can also leave a memorandum of intent or a letter of wishes. Excuse me. If we are looking for a substitute for will, for basically the same reasons as most people would want to avoid probate, provide smooth administration, reduce the cost of administration in theory, then we would use a revocable living trust. There might be other reasons to use a trust, such as having a house in another state that you wish to avoid probate on in that state, or to have the greatest incapacity type planning that you can get, which is with a revocable living trust. So we want to, again, have counseling, go through a process of education, lovingly, thoughtfully, and have intentionality about keeping it updated. Of course, there are other non-probate devices or tools that can be used, and many of you are familiar with these. Joint ownership, beneficiary designations, life estate deeds, transfer on death designations, payable on death, and in some states, what is called ITF accounts, in trust for accounts. All of these tools avoid probate. Why do most people not rely exclusively on these tools? It's because these tools are a one-way street. They do not take into consideration any other dynamics, any other possibilities, any other backup possibilities that may need to happen. And so most people do not rely on these, as exclusive tools for estate planning. However, when we do use them, we want to be intentional. And that's why part of loving estate planning is being intentional, even with tools like this. As I mentioned, incapacity planning is incredibly important. We have clients living well beyond 100. You have friends or relatives that you know are living into their 90s and into their 100s. Please be aware that non-loving planning is really ignoring this. So you must take care of yourself first. You must say to yourself, I must take care of myself first. If I become incapacitated, who is going to take care of these things that I care about? Who is going to pay my bills, take care of me, take care of my spouse or partner, take care of any person who is dependent on me? How will I accomplish my goals about the things I love, the things and the persons that I love, if I become incapacitated? When you look at your own financial powers of attorney and your own advanced medical directive through the lens of a loving approach, okay, you're going to see it in a different way, because you're going to realize you're not likely to die soon, generally speaking. You're going to likely live a very long life, and you want to love yourself first and take care of yourself first, even though we've been told our entire lives what? That if we think of ourselves first, that's selfish. We must be a selfish person if we did that. I'm going to tell you today that in estate planning, you have to think of yourself first. And only by doing that can you achieve your goals, express your love, and accomplish the things that you really wanted to accomplish. Whatever those things may be, simplicity all the way to a complex estate plan. So these documents, these things that we've been talking about, these are only tools. The whole purpose of these things is about clarity, protection, and arguably love. And we're trying to unlock that. We're trying to unlock the key of thinking about estate planning as more than just a set of documents, as more than just legalese, as more than just something that's sitting in a drawer somewhere that we haven't looked at. Or for 55 to 62% of Americans that have no documents at all. We're trying to get somewhere with getting people to think in terms of, what do I love? Who do I love, including myself? And how am I going to take care of the things I care about? So planning for life, as we say here at Elville and Associates, or planning for legacies, is really about understanding what I just said, that the powers of attorney and advance directives are equally important in my view. That planning for legacies is really about expressing your love, your wishes, your desires, your goals. And your legacy is not just this set of documents that's maybe this thick. It is a set of documents that continues to evolve. Those documents express those ancillary tools, such as letters of wishes and memorandums of intent, express. Your continuing education expresses your love, that the world is changing. If I talked to you 20 years ago, I would not be able to say to you the same thing that I can say today, which is that the world we're living in of estate planning is very flexible, very dynamic, very progressive. And it's moved so fast towards this more flexible approach, more thoughtful tools that are available, that some people argue it's gone too fast. But we're literally living in a world where for tax purposes, protection purposes, flexibility purposes, appointing special fiduciaries, being able to use tools, having access to various tools, it is unprecedented, including the assets that can be excluded for federal and state estate tax, even though we're living in Maryland and we have to deal with the Maryland state estate tax, and Maryland is a state that has the inheritance tax as well, so we have to keep that in mind. But generally speaking, being able to articulate what you want and at the same time be concerned and love yourself, there has never been a better time to do planning. For planning for life, as I just mentioned, these documents support you while you're alive. If you have a revocable living trust, you may or may not realize that your revocable trust in so many ways is kind of like a fancy power of attorney. If you become incapacitated, that revocable trust supports you similar to a power of attorney. So it's not just what happens at death. So we talked about incapacity planning, supporting caregivers, protecting yourself and your autonomy, okay? Do you have enough assets? Are your assets being managed properly? How will you pay for your long-term care? All of this is part of planning. Avoiding court involvement. Do you have a planning team? Many of you do, and many of you have done very well. Many of you do not, and we're going to get to the planning team concept here in just a moment. But do not forget that good estate planning and planning lovingly has to do with planning for life as well. I'm going to take just a sip of water. Planning for legacies, on the other hand, could include ensuring that your values last beyond your lifetime, supporting your children responsibly and articulating, depending on your level of wealth, what you want, making provisions for special needs beneficiaries or planning proactively for special needs beneficiaries, protecting assets for future generations. Many people are not aware that by leaving assets in trust in a certain way, appropriate way, that the growth of those assets in the future can be excluded from estate tax. And also you can provide for lifetime legacies and provide for asset and creditor protection. And again, we've talked about this just to drive these concepts home, communicating your wishes to family about why you are doing what you're doing, okay? I want to bring up something just to reiterate why it's so important to be very intentional and very clear and very consistent over a long period of time with your planning. We're living in a world, because of the flexibility that now exists, which generally is a really wonderful thing from an estate planner's point of view, that if you're not extremely clear and if you're not extremely educated, you could arguably articulate many things and do it fairly well and still have your intentions defeated due to an inadvertent misunderstanding of laws, where the trust is going to be administered, who you want to administer that trust, for example, making it extremely clear that you want a certain person in a certain state to be administering that trust. We live in such a multi-jurisdictional world that a trust can be in one state, a trust protector in another state, a trustee in another state, and so on and so forth, and the financial institution in another state. So part of loving planning is committing to educating yourself about these things. And of course, you have to be able to deal with a law firm who is committed to educating you about these things. And so it is about the structure, but it's also about being intentional over your lifetime. So as we say, a legacy is not a set of documents. A legacy is really peace of mind for you and for future family members, family harmony now and in the future, if as much as we can achieve that, clarity, intentionality, and it's really you carrying your love, whatever that form is that you express it in, carrying that forward. Now, why does this matter now? Well, it matters for many, many reasons. So let's talk about this in these boxes. We'll start with the left top. The most meaningful plans are driven by care, connection, and responsibility, not by the documents alone. Okay, not by the documents alone. Again, estate planning in this context is not about a set of documents, even though obviously the documents are important. Down, one step down. Estate planning is one of the most loving, selfless, and protective acts a person can undertake. It is your way to articulate your premise, your theme, your values. It's your chance to say that. And you can keep it simple, or you can be very articulate in your planning. Go up to the right-hand corner. Families who plan proactively experience less stress, fewer disputes, and greater confidence. This is not to say that there aren't any disputes. Many of us we learn that families aren't perfect. There's probably no such thing as a perfect person. There's probably no such thing as a perfect trustee, okay? But when we plan proactively, we are reducing those negative possibilities and reducing stress. Going down to the light blue box, families are more geographically spread out and health complexities are increasing. So as people live longer, we have an increasing cost of care and health issues. As I mentioned, a trust can be here, the trustees here, the beneficiaries here, the financial institutions here, the special fiduciaries in another state. And now we're dealing with a situation where we have many foreign assets that are owned by our planning clients that are living in the U.S. or living abroad, and they're still citizens of the U.S. Wealth transfer has never been more significant and will always continue to proliferate. Look at the run up in our stock market. Look at the relative wealth increase in this country. And all of these are reasons why this matters. Now, we understand that no matter what side of our political aisle that we may be on in our very divided country right now, this is another reason why loving planning matters. We certainly are seeing a world that needs more love. We're seeing our country that needs more love, no matter what side of the political aisle we may be on. And I think that above and beyond legal technical, above and beyond taxes, above and beyond asset protection, what we can really say right now is that right now, being able to start where you are with your own individual estate planning, your right of self-determination. We say in incapacity planning that a person has the right of self-determination. We say it in a more existential sense as well. I would argue that when you plan your estate planning in a very thoughtful, intentional, and loving way, you are exercising your right of self-determination. And that is your right to do as you see fit. So now is the time, now is the moment to plan thoughtfully and lovingly. So estate planning through the lens of love, I would argue, means I care about you. What are you saying? You're saying, I care about you. I want to protect you, perhaps. Or perhaps protection is a different viewpoint of simplicity. I want to ease your burdens. I want my values to endure, and on, which is why I encourage you at the outset, or encouraged you to make some notes, write on your tablet, have epiphanies, spend 60 seconds thinking about who do you care about, what do you care about, what is your driving passion. It is one of the clearest expressions of love and responsibility that exists, which is exercising our right of self-determination in estate planning, arguably through the lens of love. And as we start to wrap up, because we wanted to be very efficient today within this hour, remember that estate planning is a gift. You can also look at it as a gift. It replaces confusion and clarity with clarity. It replaces fear with reassurance and uncertainty with direction. So we could argue that estate planning is love expressed through preparedness, thoughtfulness, and responsibility. In other words, being very intentional, taking ourselves seriously, taking our right of self-determination seriously to do exactly what is on this slide right here. Now, one of the loving things I could do today, arguably, is give you not only information, hopefully stimulate some kind of thought process that you may have been thinking about, or giving you a new epiphany about some thoughts, is to give you a path forward. So here at Elville & Associates, we educate clients, but we also want to be mindful that life is very busy. You are taking valuable time this morning to sit in on this. You have many other concerns and things to do. we want to give you a path forward. It is easy. Just email me, steve@elvilleassociates.com. Email Jeff Stauffer. His email is jeff@elvilleassociates.com. My personal assistant's name is Barbara Rodden, barbara@elvilleassociates.com. And there are many other support personnel here at Elville & Associates. We want to see your current estate planning documents if you have any. Let's review those. We don't generally charge for a review of documents. We want you to bring your questions, your concerns. It is a very unusual thing to come to an estate planning attorney's office and share personal thoughts and very private things. So just remember that if you do that, you do have an attorney-client privilege. It's all confidential, even if you do not move forward and become a client. So bring those questions, bring those concerns that you have. And we want to give you the time to think. Because see, how can you develop a loving, intentional estate plan if you don't have time to think? So in the limited time that we have together, if we were to meet in the future, we want to be very efficient and give you homework assignments and checklists and videos that you can watch to try to bring this information together so that it is possible for you to do the essential things that you need to do. And that could include connecting with financial professionals. Maybe you need a financial advisor. Maybe you need a certified public accountant, a CPA. Maybe you need an aging life care manager who needs to assist you with a spouse or a loved one who has disabilities or an aging loved one. Or perhaps many times we need to connect you with an insurance professional so that we can evaluate life insurance possibilities. So we want to help you move forward, give you a path forward. It is easy, it is confidential, and we are here to educate and to be a resource to you. So with that said, I'm going to thank you within this hour that we've had. Jeff, I think we have time if anyone has any questions at all. And if not, hopefully what I've provided here is a series of stimulating ideas to stimulate thoughts and feelings about planning or reviewing existing planning. And hopefully I've given you something here that you can take away. In the future, I plan to expand on this topic, so please stand by for that if you did enjoy this. So Jeff, I'm going to turn it back to you. I hope everyone stays safe and well in the coming winter storm that's coming across the country. And I thank you for your time and attention today. Be well and have a good year ahead.
Steve, thanks very much. Well, I personally was hanging on every word there. That was really interesting. Well done. I'm sure our attendees were too. We did have a question just pop up, and now, as Steve said, is a great time for questions here at the end. We've got a few minutes. So our question is a little long, but it gets to a good point here. I have 2 needy children at home. I'll need more help in the future. 2 older children out on their own and very out of touch with the needs of the younger ones or the family in general. Do we have to communicate our intentions of trustees at the expense of offending them now? Can we plan without including them as long as there is clear communication attached to the will so they'll understand the decisions?
That is a wonderful question. Thank you for asking. I'll try to give a general answer that hopefully is helpful. I think that generally speaking, you're going to want to articulate who the trustees are now at the risk, unfortunately, of possibly offending them, because planning kind of dictates that you need to articulate that now, right? Now, with that said, and I hope this is not confusing, just only in recent year or two and in recent months, we are coming into the understanding of a new paradigm, which parents may be able to say, and again, this is going to be very personal, parents may be able to say, I don't know who the trustees are going to be right now. I'm going to take a wait and see approach on that, but I'm going to structure special fiduciaries in my documents that are going to choose those trustees in the future. That this is one of the things that we have on the table right now. Due to the multi-jurisdictional tools that are available now, it could be possible to defer who's the trustee is going to be and allow a committee a special committee of people choose the trustee, a management committee, or a trust protector to be able to choose the trustee in the future. So I think that this is going to be this juxtaposition between, peace of mind of articulating a plan that feels good and looks good, and having that kind of flexibility in the future that I just described, or saying I'm taking a wait and see approach, which maybe 5 or 10 years ago we would have thought was unthinkable. I'm going to take a wait and see approach about who the trustee is going to be, and I'm going to allow special fiduciaries or a committee or another mechanism to implement the trustee in the future. So I would say there's a vast majority of people who are going to articulate trustees now at the risk, obviously, of causing family trauma versus putting that decision off and allowing special fiduciaries to appoint in the future. One argument, I think, is if it's possible, if it's doable in your family, is to have a family meeting as part of your estate planning and trying to start bringing this together by having a third party talk about these things with the children.
Steve, thanks very much. That's a really comprehensive and helpful answer. She says, thank you.
You're welcome.
You're very welcome. Great time for any last questions. I always send out the video afterwards along with the slides again and some other resources that Steve alluded to. We've got a busy time coming up with our webinar series. Hope you can join us for some of the presentations, just a few of them. Next Friday at the same time, Steve will be back to talk about protecting what matters most, estate planning at Elder Law Explained. This is our essentials presentation, and we've switched it up a bit, and I think you're really going to enjoy it. So if you've tuned in the past for our essentials, tune back in to check out what's new. Wednesday, February 4th, we'll have Max Reamer, who is an insurance advisor with the Quantum Group. He'll be back to talk about life and long-term care insurance in today's marketplace. This was one of our highest attended webinars last year around this time, and so we're bringing Max back for some more education and information. Friday, the 6th of February, Aging Well, Planning Ahead and Understanding Your Options, and that'll be offered by Allison Stanton, who is a very highly regarded aging life care manager in the Howard County area. New presentation, one that you don't want to miss. So lots of great information coming up. We've got plenty more coming up in February and beyond, so hope you can join us. Looks like we don't have any questions. Well, actually we do. Do you have any webinars scheduled for role and selection of a trustee coming up? If so, when? Great question. So that will be, I believe, on March 6th, we'll be doing our trustee selection presentation, which we try to do on a quarterly basis. So not yet on the website. It will be within the next several days. And you'll, of course, get information about how to register for that as well. Okay, so hope you have a safe and wonderful weekend. Everybody, thanks for being here. And thanks to you, Steve, for a great job as always.
Thank you, Jeff.
See y'all soon on the Elville webinar series. Have a great day.